Good day. My name is Philippe Lortie. I'm a first secretary with the Hague Conference on Private International Law. We would like to thank the Institut Suisse de Droit Comparé and Family Law Europe for inviting us today to speak on the 2000 convention. But before doing so, we would like to say a few words about the Hague Conference on Private International Law. And to do so, I will share with you a PowerPoint presentation. So what is HCCH? It is actually the combined name of the organization in English and French, Hague Conference, Conférence de l'Haye. The HCCH is an intergovernmental organization with a legislative function. Origins go back to 1893 and a statute in 1955, where it is provided that the organization works towards the progressive unifications of the rules of private international law. Since 1955, the convention has adopted 39 Hague conventions and protocol and a soft law in different areas of the law that we will see later. The HCCH has 90 members, 89 states, and the European Union as an regional economic integration organization. And it is connected to 154 states because you don't have to be a member to be a party to a Hague Convention. So what are the rules of private international law? Rules of private international law act like traffic lights or traffic signs in directing you to the right solution when handling a cross-border dispute between two persons, physical persons or companies or a mix of the two. The first set of traffic light will guide you to what is the most appropriate authorities to decide the matter arising from this cross-border situation. Once the competent authority has been identified, that authority will have to decide what is the law applicable to the cross-border situation. And once the authority has a decision, that decision will be recognized and enforced in all contracting states parties, especially those that are connected with the matter. So we have rules on recognition and enforcement of decision. That is the third rule of private international law. Where the rules of private international law are not sufficient to provide some cross-border solutions, like in the context of child abduction, for example, then we establish rules of cooperation. These rules of cooperation are under the responsibility of a central authority, which is designated under the convention, which has specific functions as to finding the whereabouts of a person, providing information on the law of that state, or to facilitate mediation, for example. In no circumstances does the Hague Conference actually harmonize substantive law. That is not our role. To the contrary, the rules of private international law will respect the legal diversity in the different states. And by building bridges with the rules of private international law, we will ensure that these systems can actually work together, finding solutions to their legal problems. The Hague rules of private international law will respect legal diversity, be it states from civil law tradition, common law, Sharia law, or even customary law. The activities of the Hague Conference are divided in are twofold: normative work, where we do research proposals and we actually develop international conventions, protocols, and soft law, and post-convention work, where we promote convention, where we monitor and review them through meetings of states parties, where discussions take place with responses to questionnaires as a background as to how the provisions work and which provisions are creating difficulties. At the end of the meeting, states parties will actually adopt conclusions, recommendations that will provide guidance as to the way to interpret implement and operate the conventions. Sometimes the states parties will also agree that the Secretariat ought to develop a guide to good practice, a practical handbook on a very specific subject matter of the convention. It may also decide that we do a country profiles, that we actually develop model forms and implementation checklists to help with the implementation of a convention. Sometimes the Secretariat is involved in post-convention assistance, which is given on a priority basis to members of the organization. The Hague conference work is divided in 3 pillars. We have the protection of children, international matrimonial and family relations, in which is included the Protection of Adults Convention of 2000. We also have the pillar that deals with judicial and administrative cooperation and litigation convention, with conventions that you know very well on the service abroad of documents or the taking of evidence abroad, and the third pillar being commercial and financial law. The resulting benefits of the Hague Convention in the area of that interests us today is to give effect to human rights. Our child protection conventions give effect to the UN Convention on Rights of the Child of 1989, where the Adults Convention gives effect to the 2006 UN CRPD Convention. Let's move to the 2000 Convention on the Protection of Adults. Some statistics. 3% of the world's population lives in another state than the state of origin. That's 250 million people. In 2016, 10% of the persons living in Europe were born in another state than the state where they were living. That's about 50 million people. In 2015, marriages involving at least one foreigner accounted to 10.5% of all marriages in the EU. These statistics, combined with the dementia statistics we know, call for cross-border support of vulnerable persons. People in their life will have actually married with foreigners, live in another state, acquire property, have assets in different states, have families across, different jurisdictions, and inevitably they will run into situations that will call for the rules of private international law to assist with their support in a cross-border context. Let's give you an example. Ex-habituee resides in state A where she has all her assets. In the winter, X moved from state A to state B to spend the time with her daughter and family that live in contracting state B. While in state B, X dementia reaches a point where she needs special support 24/7. She will remain in state B for the rest of her life. Her daughter, who has a power of representation that has actually been granted by her mother, will be able to go in state A in order to sell the property there to pay for the special care of the mother in state B. So through the powers of representation, the mother will be able to sell the property, transfer the proceeds to state B, and pay the health care. 2000 Convention scope is that it applies to the protection of international situation of an adult who, by reason of an impairment or insufficiency of their personal faculties, are not in a position to protect their interests. What is the 2000 Convention in short? It gives effect to Article 12, legal capacity of the UNCRDP. It is complementary to the 2006 Convention, UNCRPD. The 2000 Convention supports vulnerable adults in exercising their legal capacity across borders. It affirms that the respect for the adult dignity and autonomy are primary considerations. And the 2000 Convention affirms the respect for the rights, will, and preferences of vulnerable adults. This is all provided for in the preamble of the Convention. So some policy consideration concerning the 2000 Convention. Once in a state of incapacity, the adult will need measures to be taken and or enforced rapidly and effectively because their health actually will depend on this or their property. They also will need to have legal certainty and predictability. And this is how the Convention rules have been provided. Note, in the case of a legal dispute, the incapacitated adult may not be in a position to explain their choices or to argue before the courts. The Convention rules takes this into consideration. So as to choice of jurisdiction, the rules that are provided in the convention cannot result in a conflict of jurisdiction. Only one jurisdiction at a time will have jurisdiction in relation to a specific matter. The result is that there will be no conflicting decision, thus raising certainty and predictability. With regard to applicable law, the applicable law that are provided for in the convention have real and substantive connection with the adult. Therefore, once the adult is incapacitated, cannot actually argue these rules or explain their choices, there will be very little room for conflicts, because those rules of law that would be applicable have real and substantive connection with the adult. The convention is actually drafted in a way to avoid as much as possible family conflicts when the adult is not in a position to actually explain their choices and their reasoning. It is a convention that provides for rules of private international law. The convention avoids conflict between legal systems of contracting parties by providing jurisdiction rules. As I said before, only one competent authority can have jurisdiction at a time on a specific subject matter. The applicable law rules, they will have the law applicable will have real and substantial connection to the incapacitated adult and their property. There will be very limited possibilities to contest. Powers of presentation will be giving effect in another contracting state. The convention provides rules for recognition and enforcement, making certain that any measure of protection decided in one state will be recognized and enforced in another contracting party. The convention provides for rules of cooperation between contracting parties with the assistance of central authorities. The convention provides for party autonomy in relation to jurisdiction and applicable law rules, and we'll see those in a minute. Scope is very broad, and it's not closed, it's open for measures of protections like the following: determination of incapacity, institution of protective regimes, placing the adult under the protection of a judicial or administrative authority, guardianship, curatorship, and analogous institutions. Designation and functions of person that will be representing or assisting the adult. The placement of the adult in a cross-border setting. The administration, conservation of disposal of the adult's property. And the authorization of a specific intervention for the protection of the person of the property of the adult. For example, healthcare. So, yes, there were probably some eyebrows raising when you saw the words guardianship and curatorship. Are those substituted or supported decision-making mechanisms? One will have to look beyond the words and the law and what is provided for. There is a lot of states that actually have modernized their guardianship system to provide for support decision-making. It is important to remember that the convention builds bridges between different legal systems. Not all states may have actually modernized or reviewed their legislation in the light of their obligations under the 2006 UN CRPD. That should not stop them from actually becoming parties to the 2000 convention. Some mechanisms of protection that we saw are clearly supported decision-makings, like representing or assisting the adults, or powers of presentation under Article 15, where, as I said before, a lot of guardianship and curatorship system have been modernized and can be supported decision-making today, like in British Columbia or Scotland in the UK. And if a measure is unknown or not in conformity with another state law, it can be adapted in accordance with applicable law under Articles 13 and 14 to be provided similar effects. And there will be circumstances where an adult will fall into a coma, as we saw during the COVID-19 crisis, and they may not have powers of presentation or legal representative on the spot. They may be single persons, And suddenly, some of them were actually transferred to another state because there was no more capacity in the intensive care units. And this was done either by competent authorities' decision or by guardianship decisions that we're actually taking decisions for these adults. Possible solutions in order to bridge the different legal systems and to understand them better and to see what are actually the pit and substance of the different measures of protections. The Hague Conference it's been actually identified by states parties that we will need to develop a country profile. And we hope to be able to work together with Family Law Europe, knowing that you would soon actually have a questionnaire that will allow you to actually develop a matrix of all the different protection measures that are available in Europe. Working together, we will be able to develop a country profile for the 2000 convention, if, of course, that is the wish of your organization. And we hope that this will materialize in the near future. Jurisdiction rules. The main jurisdiction rule under the convention is habitual residence. There are subsidiary jurisdiction where other competent authorities may have jurisdiction. In the case for refugee or unaccompanied adults, where it is not possible to actually identify their state of habitual residence, the state where they are present will have actually general jurisdiction to protect these people. There's also subsidiary jurisdiction that is actually for the state of nationality of the adult or where the property is located. Limited jurisdiction is available for urgent purposes, like, for example, a young adult on a ski holiday on his own. He has an accident, falls into a coma, and suddenly he has no powers of representation, no legal representation or legal representative. An authority will have to take decisions for them, be it a competent authority or a guardianship institution. And eventually the measures of protection they will put together to protect the adult could actually serve to actually transfer the adult back into their state of habitual residence. And when that jurisdiction is seized, then they can replace those measures of protections for measures of protections that will be more adequate in the state where the adult is located, habitual residence. It is possible under the Adult Convention to actually transfer jurisdiction and to also elect a jurisdiction under the convention. So there is party autonomy and there is a safeguard in relation to that party autonomy. States that have jurisdiction under Article 5 or 6, habitual residence, can actually decide, or actually on their own motion, request another authority to take jurisdiction. And that could be an authority that would have been chosen by the adult in writing. Any authority could actually also make a request to the state habitual residence or the Article 6 jurisdiction in order to have a transfer of jurisdiction. Why do safeguards? Well, as I explained before, and this is the romantic view of complete lack of capacity, Snow White, the adult may not be in a position to argue and explain the choice of jurisdiction. And it will be left to the state habitual residence in the light of the circumstances, whether to give effect to that transfer of jurisdiction to a jurisdiction that the adult will have elected in writing and may actually show in their power of representation. That is appropriate safeguard in our view. So there is no abuse. And of course, that is also the way that the authorities coordinate who has jurisdiction in order to make certain at the end of the day that there is no conflicting decision. So this transfer of jurisdiction mechanism is extremely important as it will actually avoid the possibilities for conflicting decisions. There will be other provisions for transfer, other jurisdiction, the one of nationality, a preceding habitual residence, where the property is located, any authority chosen in writing by the adult, and the habitual residence of a person close by or where the adult is present. In order to actually facilitate this transfer of jurisdiction, we invite states to use direct judicial communications and to make use of the International Hague Network of Judges. That is a possibility to actually coordinate these transfer of jurisdiction. Applicable law rules. The rules is very simple. The jurisdiction that has actually taking jurisdiction over a matter will apply their own law. In exceptional circumstances, they can apply the law of another state that has a substantial connection to the matter. The implementation of measures protections will be done in accordance of the law of the state where the measure is to be implemented. Very straightforward, Article 14. And there are other applicable law rules in the chapter on applicable law that deals with protection of third parties, the universal character of the conflict rules, because they can point to any law, not just the law of contracting states, but any law in the world. There's the exclusion of renvoi. There's provisions for the mandatory applications of certain laws, and also there is a provision concerning public policy exception. Let's move to powers of presentation. They will be giving effect through the applicable law, like a contract. They're not subject to recognition and enforcement. They are not measures of protections because they're not decided by a competent authority. However, powers of presentation that are confirmed by a competent authority then become a measure of protections under Article 3, and they're subject to recognition and enforcement law. If not, they are to behave like a contract and will be giving effect through the rules of applicable law. The law applicable to powers of presentations granted by an adult, either by an agreement or unilateral act, are to be exercised when such adult is not in a position to protect his or her own interest. They are governed by the rules of applicable law of the Convention. The existence, extent, modification, and extension of powers of presentations will be governed by the law of the habitual residence of the adult at the time of the agreement or the unilateral act. However, the adult can actually elect other laws as long as they are expressly designated and in writing. That is party autonomy, but it is limited to a number of laws that have actually a substantial connection to the adult. So they're known to the adult and they should not create any surprises. It's the law of the nationality of the adult, the law of the former habitual residence of the adult, or the law where the property of the adult is located. Do we need more flexibility? Probably not. Again, remember, there will be time where the adult will not be able to explain their law that they have chosen or to argue for those laws to be applied. So it is important that these laws don't create surprises. They are known to the adult. They have substantial connection to the adult. This is how we will avoid family conflict for those who have an interest in these law applicable, but for which they have actually no reason or they're not in any position to explain these different laws and why they were chosen by the adult. So again, no, these are all laws that have a connection or a substantial connection with the adult, and they will cover 90% of these situations. Give effect to powers of presentation. Well, yes, they're giving effect under applicable law, but there's also a system of certificate under the convention that actually may be delivered by a competent authority, and that they will indicate the capacity in which the person is entitled to act and the powers conferred by the adult in that person. So very important to actually facilitate the free circulation of the powers of presentation. The capacity and powers indicated in the certificate are presumed to be vested in the person as of the date of the certificate. So important to renew that certificate once in a while to make certain that it is up to date. There are rules on recognition and enforcement of the convention, like any Hague Convention that provides such rules. It would be possible to refuse recognition on some specific grounds that are listed here, and I will not go into details for interest of time. The convention provides for central authority designation, and they have specific tasks while they shall cooperate between each other. They should share information on the national laws and services available in their state, facilitate communication between competent authorities for transfer of jurisdiction, for example, discover the whereabouts of an adult, provide and encourage mediation, and also facilitate and assist in cross-border placement of adults under Article 33. Where do we stand? We have 13 states parties to the convention, 6 that have signed the convention. We need to do more. And I'm now referring to a meeting that we had organized jointly with the European Commission back in December 2018, and I'll show you a few conclusions, recommendations in relation to future work. Well, as you know, the Portuguese presidency made a priority of the Adults Convention and the field of protection of vulnerable adults in general. And there is, at this moment, a study conducted by the European Commission concerning a possible European norm that could complement the convention. Well, these discussions, this was discussed at the 2018 special meeting, joint meeting, with the understanding that if we were to add in more rules on party autonomy, which personally I don't think are necessary, the understanding is that it should bring real added value and should support the operation of the convention. It should not create any conflict or make the application of the convention more difficult. And it was understood then that EU normative work should not take place until all EU member states are parties to the 2000 convention. Other possible way forwards, well, more states need to be party, and we were invited to work with United Nations institutions that deal with the UNCRPD, the Council of Europe, European Union, governmental organization, as well as non-governmental organization like FL-EUR, to actually promote the convention and move forward. Other ways forward, as I mentioned to you earlier, that joint meeting recommended that we actually develop a country profile. It's now actually indicated by states parties that this is an important thing to do, so we'll start working on this in the near future. The country profile will actually help build mutual trust and confidence, so states understand each other's measures of protections and how they work, and it will be easier to actually implement them in a cross-border setting. It was also encouraged that we actually make use of Article 38 certificates, that we develop over time model forms, model provisions, model certificate, and also establish national registries to help third parties like financial, insurance, and medical institutions to verify the authenticity and integrity of powers of representation in order to facilitate their free movement. And this is a lot of possible work in the future. But most importantly, it was recommended that we actually set up a special commission meeting. It will take place in November 2022. And in order to prepare for that meeting, we've been tasked with an experts group to develop a practical handbook on the implementation of the convention. And we will have a first draft of this handbook ready in early November. And we would love to be able to circulate it to you, if you agree, members of the FL-EUR, to obtain some background and comments from you in that respect. So yes, the first meeting will take place in November. So we very much look forward to working with you in the future. I look forward to the meeting on 11th October. I will be there all day with you, and I would be delighted to respond to your questions and to work on this further. Yeah, we hope that the presentation was a useful one. Yeah, I apologize, it's a bit long. It has 10 minutes on the Hague conference at the start and 20 minutes on the convention, but we thought it was important to actually provide you with some background information. So once again, I look forward to meeting you by video on Monday the 11th, and look forward to our discussion then. Thank you very much and have a lovely week.